Hello. Most of the times, when it comes to litigation, your lawyer, experienced lawyer, a lawyer keeping your interest in mind, of course, will most probably try to discourage you from going for a lawsuit. There are many reasons for that. Possibility of a settlement, negotiation, mediation, sometimes arbitration. It's only some of them. But it is true that in most cases, at least when it comes to civil law, civil conflicts, civil litigation, civil conflicts with potential for litigation, a settlement is a better option. And often, at least statistically, the second best option is not to go for a lawsuit because, unfortunately or fortunately, uh, there are many situations when you might think that you have a good case, but your lawyer is there to tell you that, unfortunately, no, your case is not as good as you think it is. Particularly because there are many situations when an emotional, a family, personal conflict, which doesn't have particularly legal grounds, uh, is brought before a court, or at least some people try to bring it before a court, as a matter of intimidation, of vengeance, or just righteous outrage or whatever. Mm, all understandable, moral reasons, whatever, but it doesn't have this necessary foundation to become a lawsuit. Because, well, legal conflict is not the only kind of a conflict. So, usually, when you come to a lawyer, you might expect that your lawyer would try to discourage you. But sometimes, a lawyer, even like in good faith, a lawyer who is at your side, not because the lawyer would try to just drag you into some money spending exercise or so, but sometimes a lawyer would honestly recommend you to go for a lawsuit. Those are not many, uh, statistic, statistically speaking, or just in plain numbers, not many situations, but there are. What are they? I'd say for a conflict to become worth of spending a lot of time, to experience a lot of stress, to spend a lot of money, to add to the burden of our legal system, judicial system, it's all worth it if all the three, as I mentioned here on the screen, are combined. First of all, again, taking into account potential stress, time, and money, the stakes in the case should be particularly high, significantly high. It's easy to understand that spending like 10, 15, 20,000 on litigation over something that is like 7,000 and 1,000 sometimes, it doesn't seem reasonable enough. I understand that there is a small claims court, of course, but often those persons who come to a lawyer, they want to go to the full scale, the superior court. And because of that, an initial claim might be even inflated, which is artificial. So what I'm saying that the real stakes should be high. Sometimes it's not about money, like the amount is not high, but the reputation is at stake. Or when it comes to some family issues or questions of capacity, for example, they're okay. If that is the case, then there might be a first box checked, but it's only the first box. Second is that the issue, the gist of the conflict, it should be one really suitable for lawsuit, for litigation. So there should be legal and factual arguments, grounds combined to go to court, not somewhere else, not to some friends or parents or relatives, or sometimes newspapers or a political representative, but specifically for the judicial system. And there, the facts should be important facts should be clear and proven, and those facts should give good legal grounds to protect, defend some position, to claim something, and so forth. And here is where your lawyer's advice would be valuable, because sometimes you either overestimate or underestimate those. You know often that something like touches you a lot, that you feel that it's important, but important doesn't necessarily mean that it's good for a court. It might be good for something else. But let's say, yes, the stakes are high, and the gist of the conflict, with the facts as combined and proven, gives good ground for legal arguments to defend your position, to claim something like that. The next and the third, and no less important, part is whether your position is averagely good, I would say. Because if it's like really good, like 100% good, most probably you'll go through negotiations, because the lawyer of the other side would also know that your position is very strong, and probably will also advise their client accordingly. So at the end, you will probably settle. And if there is a good probability to settle, then insisting on going to court, again, it's unreasonable. And the judge will see that, by the way. Of course, there might be a situation when you have a very good, like really very good position, but the other party resists for whatever reason. Then, well, there might be a question of abuse on the other side. But usually, if one party's position is really strong, those cases are mostly settled, because, well, from legal point of view, strong, I mean, because both parties, at least both parties' lawyers, would know that. The opposite situation is when your position is like significantly weak. So there is some ground for a conflict, there is something unpleasant there, but maybe the proof is not enough, maybe the legal arguments are shaky, maybe there is a lot of fault to be allocated on yourself in the situation that happens. There again, probably negotiation or even mediation is a better option, because there might be some sort of consolation, some sort of compensation. If it comes to the court, the probability is significant that you'll get nothing. When it is really a good idea to go to court is if, with respect to some important parts of this legal conflict, relatively good arguments could be made for both sides. So you really need an intervention of a judge, of a court, somebody who would just break the tie, basically somebody who would say, okay, well, this is the equitable, fair, reasonable, legally sound solution for the situation. If that is the case, though even in that case, an attempt to negotiate and settle would be a better idea, at least a good first idea. But at least if all the three are combined, like stakes are high, grounds solid, and there are plausible arguments for both sides, so that it's really a situation where an intervention of a like high-ranking jurist is needed, then it might be a good idea to go to court. And in such a situation, your lawyer would be probably right to tell you that, yeah, going to a court is a good option. Other than that, when stakes are not so high, at least objectively not so high, they might be like emotionally high, but objectively not so high, or when the grounds are maybe good but not legal, or maybe good but not factual, or where the situation is skewed one way or another significantly already. In those situations, probably insisting when you communicate to your lawyer that it should be brought before a court, that there should be a litigation, such a way to insist might not be in your best interest. Of course, particulars is always where you should look. And if you have a particular case, of course, you should consult your actual lawyer and discuss all the facts. Those are just general factors that, in my opinion at least, should affect your decision whether to go or not to go for a full-scale litigation. Thank you, and have a nice day.